Good evening, I'm Yvonne Okwara Matola. It's now 8 o'clock. Time for our big story tonight, which is all about that deadline that's looming with just a few hours left before the expiry of that deadline for anyone willing to file a petition contesting the victory of President-elect Uhuru Kenyatta. That midnight target hanging over many petitions before the Supreme Court, including one filed by former Kilome Member of Parliament Harun Mwau earlier today. Mwau is challenging the validity of President Uhuru Kenyatta's election. The Institute for Democratic Governance has also filed a petition tonight. This one against Raila Odinga, Stephen Kalonzo Musyoka, Musalia Mudavadi, Moses Wetangula and James Orengo. The Institute has raised questions as to whether the 5 respondents committed an election offence and engaged in serious electoral malpractices and/or irregularities. Also tonight, lawyer Kelvin Jihia has filed a petition to the Judicial Service Commission seeking the removal of 3 judges from the Supreme Court. Jihia is claiming that Isaac Lenaola, Philomena Mwilu do not meet the integrity threshold of Supreme Court judges and that Mohammed Ibrahim should be removed on medical grounds. There are also allegations of intimidation of civil society organizations who are perceived to be behind some petitions. So how many can we expect tonight? And what are the key issues that may form a basis for the petition that will be filed, or petitions that will be filed at the Supreme Court? That is the basis of the big story tonight. All right, so the success or otherwise of those said petitions will determine whether President Uhuru Kenyatta gets a second chance at the presidency. Article 141(2) of the Constitution stipulates, and I quote, that the president-elect shall be sworn in on the first Tuesday following the 14th day after the date of the declaration of the result of the presidential election if no petition has been filed. In the event of an unsuccessful presidential election petition, President Uhuru could take the oath of office on the 14th of November. So here is a look at some of those timelines. And for that, we'll have to go back to Article 140, which questions the validity of a presidential election. So this is what the timelines look like from now. We know that a person may file a petition to challenge the election within 7 days after the date of the declaration. So, of course, that is until midnight tonight. Within 14 days after the filing of that petition, the Supreme Court shall hear and determine that petition, and its decision will be final. And if the Supreme Court determines the election to be invalid, then a fresh election shall be held within 60 days. However, if not, then he is sworn in on the 14th of November, or rather, if the court upholds his win, that'll happen 7 days after that. That's on the 23rd of November. So those are some of the timelines we are looking at. From today, of course, that deadline is midnight tonight, which is just under 4 hours from now. One of those petitioners, Okiom Tata, will be joining me tonight from our city center studios. We also have Advocate Steve Ogola to understand what the petitioners would base their cases on. Later on in the program, Hussein Khalid, who's the Executive Director of Haki Africa, will also be speaking with me on the alleged intimidation of civil society members. He'll be speaking with me from Mombasa. But first, as always here on the show, I want to begin with our lead reporter, Sophia Wanuna. Good evening, Sophia. So the deadline is looming. It's just under 4 hours. Can you confirm the number of petitions that have been already filed at the Supreme Court tonight?
Good evening, Yvonne. Yes, just about 4 hours to that midnight deadline for any presidential election petition to be filed, this being 7 days after the IEBC chair, Wafula Chebukati, announced and declared Uhuru Kenyatta the duly elected president. So as president-elect, that time now unfolding as far as any dispute, and here we are. We can confirm one of those petitions you mentioned, former Kilome Member of Parliament Harun Mwau, has filed his this petition here at the Supreme Court Registry. And the backbone of his petition is around the question that this re-election should be invalidated and voided because the nomination exercise, according to him, citing various laws, did not take place. He argues that when the Supreme Court voided the August 8th presidential election, in essence, it nullified every other process around the presidential election, including that of the nomination exercise. And so, Yvonne, he goes ahead in that extensive and detailed petition to explain that the several processes around nominations were all not followed, did not take place as should have taken place, arguing that that is law in as far as elections are concerned and the requirements for presidential elections, even citing issues such as requisite fees that should be made, and also highlights, Yvonne, that question around the gazetting of candidates, citing the various gazette notice and special gazette notices and the addendums, quote-unquote, thereafter, beginning by talking about the initial gazette notice was that only Raila Odinga and Uhuru Kenyatta would participate in the repeat poll. However, thereafter, there was an amendment with all the 8 candidates being included. Further on, the name of Cyrus Jirongo was expunged on the grounds that he was bankrupt. However, after that, the name was put on back on the list. And he cites all of this as some of the irregularities, also citing issues such as campaign timelines in that period of time for each of the specific candidates, so that if you expunged and brought back, Cyrus Jirongo's rights as an individual, a presidential candidate, infringed on, but also due process, even around the gazetting of the same. So the backbone, Yvonne, on that petition by Harun Mwau being around the nomination, saying that even the 5-day delay in gazetting cost IEBC precious time to be able to go ahead and conduct this in strict compliance to the rule of law, the Constitution, and other electoral laws. So we are seeing that another petition, as you mentioned, that has been filed here is by the Institute of Democratic Governance. And this one is not a presidential election petition, but it is one against Raila Odinga, Kalonzo Musyoka, Musalia Mudavadi, Moses Wetangula, as well as James Orengo, 5 respondents. And this petitioner argues that they committed electoral offenses and electoral malpractices. Goes on further to say that by so doing, these candidates infringed on the rights of the citizens. Also wants the court to find that the 5 are unfit to hold public office. And the 4th prayer this petitioner is making is that the Supreme Court should find that the damages that were made and were occasioned by these electoral offenses and malpractices should be surcharged to this individual. So that's the other petition we are seeing tonight. And also, if you want to mention that 4-hour timeline is still there up to midnight, the registry here at the Supreme Court remains open up until then. Other parties likely to come. There's all sorts of rumors about that, so we'll have to wait and see.
Hearing all day that members of civil society might be filing a petition as well. Any indications, any sources that you are hearing about this specific issue? Do we know, in fact, if which organizations these are said to be?
Yes, Yvonne, there's several reports we're receiving. We the people, John Jamue, could be heading this way to file a presidential election petition. Also, Kura Yangu, Sauti Yangu as well. We've had reports of that, Muhuri. But all of that right now is really here. Quite a number of journalists gathered here tonight and several of the advocates. The thing is, up until you actually get to the registry and really consult with the Deputy Chief Registrar who is here to get who has filed, there's all manner of reports because some of these lawyers are not widely known as would perhaps have seen in some of the cases. So they could easily just walk in and out. So it's one of those we are really keeping a close eye to be able not to miss any of these filings. But yes, today any of these parties, including the National Super Alliance. I mean, if they do so wish, there is still that timeline, as they have not expressly indicated whether they would challenge this election or not, so that even if they boycotted the 26th repeat presidential election, nothing stops them still from challenging this in court, as we are seeing a Kenyan citizen, Harun Mwau, who did not participate, challenging this election. So we'll wait to see what unfolds, at least in the next 4 hours, to solidly be able to paint a clear picture of what we'll be seeing the matters before the Supreme Court in the next 14 days. Yvonne.
Yes, and just to let our viewers know, Sophia, what you told us, that the true confirmation of whether indeed these petitions have been filed is with the Supreme Court Registry, yes? So we may see people walking in and out, we may hear all sorts of rumors, but until we get that confirmation from that office, you know, it would be hard to speculate, correct?
Yes, it will be difficult to speculate. And Yvonne, just to remember also the Harun Mwau petition, the presidential election petition, this is a matter that was before the High Court. Again, he'd raised the same issues. And so the matter then at the High Court, the judge finding that it had no jurisdiction over a presidential election petition, that the Supreme Court, having original jurisdiction, should canvass that. And that is how this matter moved here. So it's one that he has sought to have the court deal with up until now. I know we have Okia Tatas with us tonight on the show, and perhaps one of the things we are hearing, whilst his petition was filed before this timeline for the presidential election petition began, it could very much be consolidated with the petitions, because as well it's challenging and bringing up issues about the interpretation of the IEBC in gazetting the candidates it did, but more importantly for Kia, around when Raila Odinga decided to boycott at the time, what was the applicable law? Because the grounds for which, you know, Raila Odinga did boycott is citing, you know, that advisory of the 2013 Supreme Court, which then would have meant we automatically go to nominations. So nominations are a big one this time around. It will be very important to see how this Supreme Court interprets that issue. Also, is the advisory of the Supreme Court binding, as opposed to what we had the High Court judge Mativo in allowing a Kuru Court and other candidates to be involved? He found that the advisory of the 2013 Supreme Court had no legal binding on the Supreme Court. So again, we'll in essence also have an interpretation, if that matter is in fact consolidated with these petitions, on whether their word, whether it's in a matter substantively before them or it's on an advisory, is binding on all other courts. Yvonne.
All right, thank you very much for that. Sophia Wanuna, our lead reporter. I just got a flashback of just after the August 8th election, Sophia staying on that story until well past midnight when that petition was filed at the very last moment. Of course, when that happens, we'll bring you all the latest here on KTN News. So let's start our discussion. We have Steve Ogola, who's an advocate to the High Court. Steve, good evening. It's good to have you with us. Also, I see Okia Omtata, who will be joining us from our city centre studios. Like we told you, he filed his petition even before the results were announced. And again, later we'll be speaking to the executive director of Haki Africa. Claims of intimidation of members of civil society who may be filing a petition in the next few hours. We'll be speaking to all these gentlemen. Thank you very much for being with us all. Steve, let me begin with you. What do you make of what we know so far with Harun Mwau's petition and perhaps the others that may be coming within the next few hours?
Thanks, Yvonne. I think it's important, first of all, to clarify to Kenyans that petitions that were filed before the declaration of results are not petitions for purposes of nullification of presidential election. They may have the intended consequence of nullifying the election, but they will not nullify this election, including Okia Omtata's petition. If you look at Article 140, it says any person who wishes to challenge the declaration of results and the declaration of the president-elect may file a petition within 7 days after that declaration. So anything filed before then, although touching on the issues regarding the election, one, will not have the intended consequence of nullifying the election, and two, will not be determined within 14 days. and as a consequence, will not be consolidated. I think it's important to clarify that.
All right.
There may be, if somebody like Haron Mwao's petition highlights the similar issues, the issues will be canvassed in Haron Mwao's case, and the evidence tendered in Haron Mwao's petition will be examined in isolation from Okiya Mtata's petition. So for me, the way I see Okiya Mtata's petition, it is one of those petitions that will not be determined within the 14-day window period and will not have the intended consequence or benefit of nullifying the election, if that is what you had intended.
Okay, Steve, I'd just like you to hold that thought there, because you've mentioned Tata's petition, and we have him on the show with us, so I'd like us to hear from him. Tata, good evening. Have you heard what Steve Ogolla is saying about your petition being filed before the results were announced and therefore not falling within the 14-day window period, and perhaps not having the intended consequence that you might have wanted it to have?
Well, I think I've heard it, and I think he's taking a very narrow view, a very narrow reading of Article 140. He should also read Article 163, which gives the Supreme Court the jurisdiction to look at issues under Article 140, and it's not necessarily limited to the outcome of the presidential election. Any issues that arise within the process are issues that are due for determination. And I think that, well, I will leave it to the court to guide how it will go, but the issues that arise in my petition are issues that arose before the results came about, and my petition is not challenging the results, it's basically challenging the validity of the entire process, irrespective of what the results and outcomes were, and that's why I intentionally filed it before the results were out. In fact, I had gone to file it the day before the elections, but the Chief Justice directed me to file it on Friday. That's what I did on the Friday.
All right, so are you hoping at any point that your petition will be consolidated with the others, Haron Mwao's, or perhaps any other that may come in the next few hours?
Well, I think the issue of consolidation is for purposes of the court to decide if it is going to save its time to look at if the issues are similar, and are raising the same thing, the court may choose to consolidate or not. But I know that the best practice would be that all these petitions might be had together, and so that the issues are determined once and for all. It would have no point for the court to go and determine one petition and then come back again, look at another petition and do stuff like that. So from where I stand, to me it is that Mr. Ogolla has given his opinion. I think it's the court which will give a direction, and as we speak now, I was directed to serve. I'm supposed to receive the replies tomorrow, by the end of the day tomorrow, and then I'm supposed to put in supplementaries, and then we go back on Friday for purposes of deciding how the matter will be heard.
Steve,
Friday 10th.
All right. Steve, perhaps we can now start to talk about the other issues that may come up, before the courts, perhaps anyone that might want to challenge this, other than the grounds that we've heard from Haron Mwao. Could you speak to Haron Mwao's petition, as well as what you think might be the other issues that the court might want to consider?
If you may allow just for 2 seconds to comment on David Posing's petition, which also has been filed. That petition is intended to affirm the results. Article 140 does not require petitions that seek to affirm. It requires petitions that challenge the results. So David Posing's petition will also suffer the same fate. But having said that, this petition by Haron Mwao raises, just like Okiya Mtata's petition indeed, in terms of the substance, they raise serious constitutional and legal issues that are ripe for determination. Now, the question of gazettement, irregular gazettement of candidates, the inclusion of Jirongo's name in the ballot paper, way ahead before he was gazetted, that question must be examined to full effect. The question of Raila Odinga's withdrawal was not well explained. We are aware that Raila withdrew from the race on the 10th of October. The consequence of that withdrawal, at the time of his withdrawal, IBC had gazetted Raila and Uhuru on the 5th of September as the only candidates pursuant to the 2013 Supreme Court judgment. That same judgment at paragraph 290 says that if you have two candidates and one of them abandons the race, then the election stands cancelled and fresh nominations to ensue. I think that's a question that, if not well explained, may as well reverse this election, and IBC needs to watch out for that question. The third issue regards the appointment of returning officers. The Supreme Court, although IBC was clever to have gone to the Court of Appeal to have that decision by the High Court stayed, but the Supreme Court will examine in terms of assessing overall compliance, because Yvonne, the court said they are happy to excuse anything but not compliance, non-compliance, lack of openness, and lack of demonstrable competence. So compliance, openness, and competence is the three test standard that the court will be examining. When it becomes when the issue of appointment of returning officers is raised, it may have some value in terms of helping the court to assess whether IBC was really complying with the law, because what the High Court did was to suspend the implementation of that judgment, but did not take away the merits of the arguments in that judgment. The other issue, remember, the highly contested issue of the voter turnout is likely to find the pride of place in this petition, because I have studied, and people who are familiar with election day management, IBC's own manual, polling day activity diary, that requires presiding officers to record at intervals of 2 hours at 9 a.m., 11 a.m., 1 p.m., 3 p.m., and 5 p.m. voter turnout, and to transmit this voter turnout via text message to the constituency returning officers. And the court will be interested to know, were the presiding officers sending this statistical data via text message for the returning officers' own amusement or for collation and onward transmission to the National Tallying Center? And is it possible, therefore, to have provisional voter turnout? In my view, it is not possible to have provisional voter turnout. It is possible that after 6 hours, after the close of voting, in fact, the second level of verification of voter turnout is that after the results have been counted and announced, when the presiding officer is sending those results via the KIMS kit, he was supposed to include what Chebukati was calling the logs in that KIMS kit. So Chebukati did not attend the issue that the same figures were being sent via text message. If left unexplained, that may have significant impact on this election.
All right.
Of course, the other issue in Garissa, where there were voter turnout in excess of the registered number of voters, that issue will also probably find the pride of place in terms of examination. And of course, we cannot downplay, Yvonne, the consequences of Commissioner Kombe's resignation, because you see, IBC ought to be independent in order to manage the election. If a commissioner resigns, not citing health issues, but citing frustration and saying that this commission is not capable of delivering free, fair, and credible election, and that argument is buttressed by Chebukati the following day, saying that he's been overruled even on issues of law, I don't think it's safe for IBC to assume that the Supreme Court will not examine the circumstances under which the commission actually managed the election. If there was evidence that the commission was susceptible to external manipulation, then that issue might actually affect how the judge, how the judges sort of apply their minds to this election.
Steve, I just want to ask you one more question, because I want to bring in Hussein Khalid for just a moment. I want your comment on other cases that have been filed outside of the Supreme Court and to see if you think that they might affect what will happen at the Supreme Court. And I'm referring to the case that's been filed by Apollo Mbowe. He's the former CEO of the Law Society of Kenya, and he's challenging what happened at the Court of Appeal with respect to that case that was filed by Khelef Khalifa and yet another citizen of this country. And this was regarding the appointment of the returning officers. And he's questioning how the Court of Appeal was able to sit on that day that was a public holiday, saying they sat at night, that it was irregular. I mean, I don't know what you think about this case and whether at all it'll affect anything that may be heard at the Supreme Court with respect to the appointment of returning officers.
Affect the determination of the petition. First of all, there's a judicial decision by the Supreme Court judges themselves that say judges cannot recuse themselves in a manner that to render the ability to sit almost impossible. They will take note of any issues raised by litigants, but nonetheless the bench must sit. So I don't see a possibility of judges saying that now we are unable to sit because of issues raised around our integrity, around our impartiality. They will take note, but they will sit. The other issues that are raised around the election management, well, they are very nice issues because they bring clarity in election management, but in terms of the framing of Article 140, Yvonne, unless this is an election petition challenging the outcome of results declared and is filed within the 7 days after declaration, Any other petition around election management will not be determined within 14 days and will not have the intended benefit or consequence of nullifying an election.
All right. Okay, I think on that we're clear. I'd like us to focus now on what's happening with civil society, because we had heard word that they might be planning to file a petition at the Supreme Court regarding the October 26th repeat presidential poll. And then we heard of cases of intimidation following the summons by the NGO Coordination Board. We have with us Hussein Khalid. He's the Executive Director of Haki Africa in Mombasa. Hussein, what do you make of these allegations of intimidation? We understand they say they will not honor the summons. What's your thought?
Thank you very much. First of all, I don't think they are allegations. The facts are open for everyone to see. Article 36 of the Constitution of Kenya is very, very clear that any person has the right to belong to any form of association. And that same article further provides that should there be any legislation that requires cancellation of any form of registration, then it will be mandatory that it provides for a fair hearing. Hello?
We can hear you.
Yes, so I think the Constitution is very clear and the laws are very clear. If you look at this example, in this case, not enough time was given. As a lawyer, legally speaking, you need at least 14 days for if anyone is supposed to present their case on a fair trial matter.
Hussein Khalid, I'm sorry to interject for a moment. We're keeping our eye on what's going on at the Supreme Court right now. We'll come back to you shortly, but our Sophia Wanuna is outside the precincts of the Supreme Court. Let's see who she's got with her to speak about whether there's a new petition that's been filed. Sophia?
Yes, Yvonne, with me here are some voters. They'll tell us more about themselves and the petition they're seeking. They have actually just submitted it at the registry here at the Supreme Court. So the registry is reviewing it. They'll get word shortly. But let's hear from them. Sir, tell us your name, the organization, if at all you represent, and about your petition.
Okay, my name is George Bush. I'm the chairman of Black Flag Movement. With me are my colleagues. So we came to file a petition today. At least, by good luck, we have managed to catch up with time. But what we seek majorly is that the rivers of blood that Kenyans shed to stop this illegality on 26th of October from taking place, we as members of the Black Flag Movement insist that it will not go scot-free. We will not betray it because, as you are aware, Madam, there are Kenyans who are still in hospitals, who are shot, who are victims of the collective feats of police brutality. Others are just buried the other day. Others still remain. We don't even know they disappeared. So we want to ensure that this, the heroism that Kenyans displayed in the run-up to the election is not betrayed at all.
So who are the respondents? Who are you suing?
In our petition, we have sued the IEBC, we have sued Uhuru Kenyatta, and we have equally sued Raila Odinga, because we are neutral, as we don't belong to any, we don't affiliate ourselves to any political side. But all we insist is that if an election that should be, the topmost ritual of a democracy can result in unwarranted deaths, then all participants, especially the major participants who participated, should all of them should be brought, they should collectively, or the entire exercise should be set aside so that we have a peaceful process where Kenyans don't have to shed their blood, in pursuit of democracy.
So to clarify, is the deaths occasioned by the incidents of violence you witnessed around the country? That's the grounds for your petition?
Majorly, the major ground, other than that is also a ground, but the major ground is that there are constituencies in this country which never had the opportunity to vote. There are more than 25 in number. And as you are aware, Article 138, Article 2 of the Constitution, provides that for an election to meet the threshold for declaration by IBC, all the constituencies must be able to vote. But we are aware and we know, and in fact the chairman admitted when he was declaring the results, that there are certain counties and even constituencies where the voters never had the opportunity to vote. So this is a case where a president wants to serve, because generally if you don't vote for president, you don't owe him any loyalty. You are not bound by any of the decrees that government would emanate from that government, because as far as you are concerned, that government is unconstitutional. And
so even if Raila boycotted the election, you're still suing him?
We sued him because equally Raila withdrew from the election, and we are aware, but the IBC insisted on including his name in the ballot. So we want to know more why the IBC included his name in the ballot even after withdrawing, and he would come to the court and tell Kenyans. This would be a platform where he will now come and tell Kenyans whether he really approved of this misdemeanor of IBC including his name against his wishes.
Finally, you are filing this petition with a special request to the court.
Yes. We want the court to set aside these elections, and that is the major prayer.
But the request around the charges, sir?
Oh, of course, we are poor Kenyans, and the drafters of the Constitution gave us a soft point in the Constitution. Article 46 of the Constitution, I think we have quoted it here. Article 48 of the Constitution, sorry, provides that any Kenyan has a right to access justice. And if there are court charges, those court charges should be reasonable. But in our case here, we have clearly indicated that we are not from very well-off background, and that we cannot manage the court fees that has been imposed by the Supreme Court, or whichever laws that came up with that fee. And now we are filing it we have drafted a form of pauperis, a draft that is seeking to exempt us from the court charges or the court fees.
All right, so you've handed it into the registry. You are waiting word if it has officially been accepted.
Yeah, we are waiting for, I think it has been taken to the registrar. That's what we've been told, to have a look at it. Then we'll have a brief meeting with the registrar, and we'll see the way forward. But definitely, if the Constitution is the book that Kenyans respect, then I hope the registrar, being a Kenyan, will ensure that this petition is filed. If it is not filed, today we are going to sleep here in protest.
Okay.
Yes.
Many thanks.
Thank you, sir.
Many thanks, sir. Yvonne, another petition, perhaps one that we're waiting to see in the next few moments. It has been received. We were at the registry as he was handing it in there, accompanied by other members of this group. And the officer there has said he will be consulting with the registrar just to look at if they have met all the requisite parameters, and as far as filing a petition, and also that application to not pay any of the charges, because remember that as well is part of the processes that allows for a petition to be allowed or disallowed. So will that be put into consideration? We'll wait to see and report when we find out, Yvonne.
Thank you. Sophia Wanuna, live from the Supreme Court. Another petition from George Bush of the Black Flag Movement. We'll continue to keep you updated. This is our big story today as the deadline looms and the clock ticks towards midnight tonight. We will come back. My conversation with the Tatas, Steve Ogola and Hussein Khalid of Haki.